I have the privilege of serving in one of the most diverse communities in our country, and immigration issues and collateral immigration consequences of criminal sentences are issues our judges face daily. In Padilla versus Kentucky, the United States Supreme Court held that the Sixth Amendment requires defense counsel to provide affirmative, competent advice to non-citizen defendants regarding the immigration consequences of his or her guilty or no contest pleas. Under the court's reasoning, this duty also extends to any other serious penalty similarly enmeshed with criminal charges or convictions, where in practical effect, it is difficult to divorce the penalty from the conviction. Although the duty to advise the defendant of specific immigration consequences and other penalties lies with the defense attorney, judges have a role in making sure defendants are aware of these potential penalties. As set forth in Standard 14-1.4 of the ABA Standards for Criminal Justice Pleas of Guilty, before accepting a plea of guilty or nolo contendere, the court should advise the defendant that by entering the plea, the defendant may face additional consequences, including a change in the defendant's immigration status, and that the defendant should consult with defense counsel if the defendant needs additional information concerning the potential consequences of the plea. The court recognized that preserving rights such as immigration status may be more important to the defendant than any jail sentence. In fact, many judges who preside over criminal courts already warn defendants taking a plea that the defendant's plea and conviction subject the defendant to deportation. The court in Padilla has asked us to take one step further. Based on the Padilla decision, it is now important to make sure that the defendant has had appropriate time to consult with his or her attorney and that they have indeed discussed the immigration and other enmeshed penalties that will result from the plea. The Supreme Court also explicitly encouraged the defense and the prosecution to reach creative resolutions during the plea bargaining process. Informed consideration of possible deportation can only benefit both the state and non-citizen defendants during the plea bargaining process. By bringing deportation consequences into this process, the defense and prosecution may well be able to reach agreements that better satisfy the interest of both parties. The court noted approvingly that counsel should plea bargain creatively with the prosecutor in order to draft a conviction and sentence that reduce the likelihood of deportation. Trial judges should echo the Supreme Court's encouragement to defense counsel and the prosecution. This creativity does not create any special benefit for certain classes of defendant. Rather, it embraces the Supreme Court's recognition that some defendants suffer far greater penalties enmeshed with certain criminal dispositions, and a fair and just process entails a proper and complete consideration of these consequences as each individual case warrants. If the court fails to make such an inquiry, the plea and sentence may be challenged on direct appeal or collaterally by the defendant. Finally, when conducting a plea colloquy, there are some general principles a judge should follow. Do not ask a defendant or defense counsel to disclose his or her citizenship or immigration status either directly or implicitly. Encourage defense counsel to take seriously their responsibility to provide competent advice regarding immigration consequences. This should be done at every stage of the criminal proceeding and as early in the case as possible. Inform defense counsel about resources available, including this video. Provide the defendant with additional time to consult with defense counsel about specific immigration or other consequences if requested. It is very important to remember that the duty created by Padilla falls on the defense attorney. The judge's role is to ensure that the defense attorney has met those obligations. It is not the judge's role to provide individualized advice on immigration penalties or others. Even so, a full judicial colloquy about immigration consequences may not protect a case from coming back on appeal for ineffective assistance of counsel. the more difficult situation arises when a defendant comes before the court without an attorney. In those situations, there are a few steps you as a judge should consider taking to assist the defendant. Be willing to continue the plea or sentencing hearing in order to give the defendant time to speak with a criminal defense or immigration attorney. Prior to conducting a plea colloquy, provide the defendant with a written plea form in the language primarily used by the defendant, which advises the defendant of the rights he or she will be waiving, that explains the plea will subject the defendant to deportation or other penalties, and that the defendant has the right to first consult with a lawyer about immigration and other consequences which may result from the plea, and provide the defendant with a list of resources available to them. Thank you.
That concludes our Padilla presentation. We certainly hope that this information has been helpful to defense attorneys, prosecutors, judges, and members of the public. It is always the goal of the American Bar Association Criminal Justice Section to present a balanced approach to criminal justice issues that takes into consideration the roles of prosecutors, defenders, academics, and the judges presiding in these cases. If you would like more information about the ABA Criminal Justice Section, please visit our website at www.abanet.org/crimjust, or just call at 202-662-1500. We would be happy to serve you. Thank you.